Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I am Thomas Vick, joined by my co-host, Seth Wilson. Seth, how's it going today?
Thomas, I'm doing wonderful. Thanks for joining us today. It's another sunny day here, and we've had some really good weather recently, so it hasn't been super hot or anything. Always looking forward to getting together with you and catching up on the world of estate planning.
Well, I am glad that the weather's been good for you there in balmy Noblesville, Indiana. Here in Greenwood, yesterday, I had to run out to my car at a full sprint and had to cross a pond to get to my car. It was just pouring down rain so much. My pants were soaked by the time I got in my car. So glad the weather is good for you up there.
Well, we need the rain so we don't have to water the grass and keep it going, right? So,
Yeah, that's right. But
well,
otherwise, doing pretty good. Doing pretty good. Blog Digest is about to go out tomorrow, so we kind of wanted to talk about some of the topics that will be going out tomorrow, and a wide range. But we kind of wanted to talk about one in particular, some of the myths of estate planning, and we can kind of go back and forth on those and discuss them, and maybe allude to some of the other topics that are mentioned in the blogs this week.
yeah, I thought that was kind of a good thing. There are many times that I will have a meeting with a client and we'll kind of talk through what's the difference between a will and a trust, and what about intestate succession? Do I really need a plan in place? And I thought your blog digest kind of brought all of those, really a lot of frequently asked questions that I face in my practice together. So the first one is that you only need a will. And where I see this coming up a lot of times is there's some confusion between having a living will and a last will. So tell us a little bit about the distinction there and why you do need more than a will for estate
Yeah,
planning.
yeah, that is what people say. I need a living will. That's what they say, and what their clients are actually asking about is a last will and testament. And why do you need more than one? Well, kind of understand what the limitations of a last will and testament are, the purposes of the last will and testament. The main purpose of a last will and testament is to determine who gets your assets, your stuff, after you pass away. There are a couple aspects to it that could have some kind of effect on your loved ones, but mainly it's really dealing with your property. And so uh, there's more to your life than just your property, and especially there's more to your life with regard to your property while you're living. And so that's why you need more than just a will. You need to be able to deal with the challenges that come up while you're living in order to be fully protected.
Yeah, and that's such a great point and way to think about the situation. There is so much more to you and your family potentially than just what happens to your stuff when you pass on. Because what happens if there is a during life incapacitating event, where that power of attorney may be helpful and those kind of things. So I think it's really good to just think about it from more of a 360-degree view rather than just, well, I need to worry about where this particular item is going to go or this bank account is going to go.
Yeah, having that power of attorney in place is super important so that financial decisions can be made. Kind of a robust estate plan will have a last will and testament, a financial power of attorney, an advance directive, HIPAA authorization, and what truly is called a living will. So, yeah, those documents are all part of a full estate plan.
And Thomas, I can't tell you how many times I've heard this from clients who have come in of, boy, I'm really embarrassed. I haven't done my estate plan yet. And so this next myth is that only seniors need estate plans. And obviously that's not true. That's why we're calling it a myth here, but we want to talk that through. But I always tell folks, look, if you're coming to see me and you don't have it done, that means you haven't needed it. So that's a good thing. So, but the importance of this particular one, and really addressing the issue that, hey, if you're sort of older in your life stage, that's not only a good time to have a will, but younger folks and young families in particular could benefit from having a will.
Yes, and the uncertainty of life is one reason why you need to have an estate plan before you become a senior. Who knows what can happen to you over the course of, your 20s, 30s, 40s, 50s, all of that all of those years there has some kind of risk that an incapacitating event may happen to you, which would require a guardianship. And so it's not just for seniors. Risk is for everybody. But also, you got to take care of some people, right? If you're a parent, you've got to take care of your kids and be able to say, what happens to my kids if I become incapacitated or if I predecease my kids and there's no other person to take care of them? Who's going to take care of them? Well, you do that through estate planning. You do that through a power of attorney and a last will and testament to designate who's going to serve as guardian of my children. So those are reasons why individuals who are not seniors should do estate planning.
Yeah, and I would just second that as a peace of mind for your family, just knowing that there isn't going to be unnecessary additional challenge for your family if your documents are appropriately put into place. And that naming of the guardian, especially for young families, is just such a vital component. And I think you even have kind of a specific blog digest topic coming out on the importance of naming the guardian. I would encourage people to check that out as well.
Yeah.
So
yeah, go
who
ahead.
needs a will? Is it only rich people?
It's not only rich people. So parents who have kids, right? They need to have a will for that reason, regardless of how much money that they have. In Indiana, we have what's called a small estate affidavit, and you can avoid probate if you have less than $100,000 of probate assets. But even then, if you have assets, you need to direct those to some place or to someone, and so that's $100,000 is a lot of money, yes, but it's not. I don't think people that say they have $100,000 are saying I'm rich. They still have some planning that needs to be done to do a will and all of that.
Yeah, and I think that's one of the big myths around the estate planning world is just I don't really have anything of value. Well, that doesn't mean that somebody else in your family doesn't value whatever that is and could make life challenging for the other beneficiaries. And or if there is no clear written plan, maybe state law controls what happens, and that may not have the intended outcome that you desired for what assets may be there, as modest as they may be or as extensive as they may be. And so having the plan in place can really help with that already challenging time when someone passes away, just making it as clean as a transition as possible between ownership of a particular asset, or even if it's maybe something that's just of sentimental value, that personal property that can avoid that family conflict down the road.
Yeah, I've heard a story from an older attorney that he kind of told me a war story one time where it got down to just two siblings, and they were fighting over just some little pieces of jewelry here and there. And there was going to be a really, really long hearing on who was entitled to the jewelry. And what it came down to was the judge told the attorneys, take your clients to your office and have an auction. And whoever pays the most, put it into the pot, put the proceeds into the pot, and then we'll split it up that way. So just some awkward situations can come up if the parents or whoever is creating the will if they don't provide for details about what's supposed to happen with certain items. And so that's a great reason to have a will, right? So you can avoid those conflicts and state your intent without any doubt as to what's supposed to happen.
Yeah, and it is such a gift to your family to have prepared all of that in advance and not leave those questions open. And so that kind of ties into myth number 4, which sort of culminates some of the other things we've been chatting about, which is that estate planning is only what happens after death. And I think that's a big misnomer of, well, I don't really, I'm not there yet, so I don't need to think about it. I'm not close to that point, most likely, statistically, whatever you want to say. But as we've talked about, these incapacity events during life can actually be as important as what happens after your passing.
Yeah, so true. I mean, you've got to be able to deal with what's going to happen during your lifetime. And I think on occasion, clients have called my office and they've said, I need an estate plan for my loved one when the loved one has actually passed away. They think an estate plan attorney is the one that is going to actually make sure that it goes to, the property goes to the people that the decedent really intended it to go. And that's not what we do, right? We're just stuck with the circumstances as they are at death. And so we really need to be thinking about what do I need to plan for while I'm living so that my intent is carried out. And some of that intent hinges on what a power of attorney says. If a power of attorney says that, so-and-so can step into my shoes and do anything and everything that they need to do that I would be able to do if I were fully capable, that's great. Or maybe you want to put restrictions on that power of attorney so that you can't sell property or you can't gift too much money to an individual. There may be some restrictions that you want to put onto the power of attorney to make sure that your intent is carried out.
Yeah, and I think part of that too, Thomas, is the reality of the potential need for a guardianship. And when you have a scenario where your loved one may have an incapacitating event, be unable to make decisions for himself or herself, not having that power of attorney in place often means getting the court to establish a guardian over the person and property of that individual. And that can be just a challenging situation in and of itself because of the fact that when you involve the third party decision maker, back to your judge story of, this is how we're going to handle this by the auction, that individual now is in charge of your family's situation. And you're going to be dependent on how that judge views this situation and what their legal obligations are to the protected person and all of these different things. And so having that plan in place can be so valuable for the family should that incapacitating event during life occur.
Yeah, absolutely. Absolutely. And not nearly as expensive as a guardianship, right?
Absolutely. Absolutely. Well, then the final myth that is in your list, and I'm sure there's more that we haven't really thought of, but these were some good ones. But
come on.
what our plan was, or what once your plan is set, then you're all set. Almost like, hey, this is a set it and forget it situation.
Yeah, and what we recommend instead is that you review your estate plan at every major life event, and maybe not more than every 5 years. And the reason for that is with every major life event, it has potential to have an impact on an individual's estate plan. So say you have a trust set up. It's a beautiful trust. It's for your kids. Kids are not married at the time. They're adults, but they're not married at the time that you set up the trust. And then one of them gets married, say the oldest son gets married, and you don't really like the daughter-in-law. you're afraid that the daughter-in-law may take the son's money, and so there's some concern about that. What restrictions can you put on that trust in order to make sure that the trust doesn't become part of the marital property? Can you kind of withhold the property so that the trustee has discretion to distribute funds to the son, but not give the son a withdrawal right that would be subject to marital property distribution or settlement agreement? That's the kind of life event that would happen and have an impact on an individual's estate plan. And, there are, an innumerable amount of circumstances that could potentially change your estate plan. Maybe there's a disability, or maybe there are grandchildren. Maybe you want to change who your beneficiaries are entirely. All sorts of things could happen. And so that's why we say every major life event, and no later than every 5 years, have your estate plan reviewed.
Yeah, and our approach in this area is to follow up with clients on a annualized basis from the date they've last updated their plan. And quite frankly, we do tell folks our intent is to make the documents as evergreen as possible, meaning we're trying to draft for what we know and what we can reasonably anticipate. And obviously, there's going to be life circumstances that we just don't know are going to happen. And so we try to follow up with folks and get kind of an annual review. Sometimes that's good to connect with a meeting with a financial planner if you're working through that process, and just say, are there any life changes that we need to address? But certainly, as you say, on a 5-year period on the outside is probably a good time to take a look at those things and make sure that we are allowing those documents to be updated should it become necessary. The other factor to consider is a change in the law. And so if we see that there are situations that are coming for clients, and we've talked about in the past of, hey, the federal estate tax thing is going to change here in a few years, and that's going to be the topic of discussion for a lot of estate planning lawyers as time draws nearer to that deadline. That may be a time that you're wanting to pick up the phone and get in touch with your attorney just to say, hey, has anything changed that affects my scenario? And so any of those big life events or some sort of routine review of financial related things, I think are a good time to pick up the phone and have a quick conversation with an estate planning attorney.
Most definitely. And I'll just, as a segue, offer this example of a life event. Perhaps after you've done your estate plan, all of your named personal representatives, or executors as some people call it, are not able to serve anymore. Maybe they've predeceased, or they're just too feeble to be able to handle the situation. What do you do in that situation? And so I'll kind of open the floor up to you, Seth. What are your suggestions for somebody that doesn't have an executor to name?
Yeah, what a common situation, especially as folks are a little bit older and their family members have maybe passed along, and their children are no longer here, or something along those lines. And there are options available, such as hiring a professional to handle that, a professional personal representative or trustee to manage your affairs. You can find a trusted attorney potentially that didn't draft the documents necessarily to serve in that role because of their familiarity with that. A trusted friend, someone who you go to church with perhaps, or have a long-standing relationship with, that they would be comfortable stepping into those shoes and helping fill this out. And so I think too, on your blog digest, you have an article with some other things to consider here, but those are typically the ones that we look at. The question we often get is, can you, as the attorney, serve in that role? And I just take the position no, because if I'm drafting the documents and I'm the personal representative, it doesn't work well from my standpoint. I don't think I can be completely objective in that standpoint and maintain my duty to the client in that scenario.
Right. And oftentimes, because the client trusts you, they want you to serve in that role, and you just have to take a step back and say, I'm flattered that you want me to serve for you, but also that's not maybe the most ethical thing for an attorney to do. So I'm with you on that, in full agreement. But naming another attorney could be an option. So an attorney's office that has a relationship with another attorney might be a way of handling that situation. And sometimes, depending upon the level of assets that are involved, it might make sense for a corporate trustee to serve as the personal representative or as the trustee. Maybe not. Those are expensive. The way that those generally work, as I understand it, is not only is there a charge for an investment fee, first of all, you got a minimum balance that you have to have in the account, and it's $500,000, $1 million. It's a large sum that the estate or trust must have. So you got to cross that threshold. But then beyond that, you've got the expenses that are a part of that trust administration by a corporate trustee. You've got the initial investment percentage that any kind of financial advisor gets, but then on top of that, you got a percentage of the trust corpus that is the trustee fee. So that can be pretty expensive when it gets down to it. And, there are some other options that are available that might be quite a bit cheaper.
Yeah, all good thoughts there. And that's really one of those fact sensitive decisions that you need to talk through with an estate planning attorney. And that may be the best value the estate planning attorney can bring to that scenario. Is your estate itself may not be super complex in terms of outcome, but making sure that someone is properly assigned to that role to serve, that's an important step of the process. And again, worst case scenario, the court would appoint someone, probably a member of the local bar association or something, to serve. But those fees then are paid to that individual who had no connection potentially to the family or what's happening there. So there's not, it's not going to be the end of the world if that doesn't happen. There are mechanisms and processes in place to help with that transition, but it may not be exactly how you had intended for it to happen.
Definitely. Well, those are the myths of estate planning, the 5 myths. There may be more, as you said, but we've covered 5 of them. Seth, how can people get in touch with you?
Thomas, we are located here in the heart of Hamilton County in Noblesville, Indiana. That's our web address, noblesvilleattorney.com. How about yourself?
The best way to get in touch with me is by going to my website, vicklaw.org, and book a call, vicklaw.org, and select book a call, and I'll be able to talk to you by phone or by Zoom. So that's a great way of getting in touch with me. I enjoyed it as always, Seth. We'll talk to you later.
Sounds great, Thomas. See you later.